Good afternoon, everyone. As you may all know, I am Joebert Facun and currently studying at Tarlac State University, taking up Bachelor of Elementary Education. And our today's agenda is the discussion about the types of rights under the law of copyright. And here are our objectives. At the end of the discussion, the students should be able to define and explain the types of rights under the law of copyright, realize the significance of each rights, develop a literary and artistic works considering the law of copyright. And here are the things to be discussed. First, we will tackle about what is copyright, and also we will discuss the types of rights under the law of copyrights, which are the economic rights and the moral rights, and also the exceptions to moral rights. So first, let us talk about copyright. So when we say copyright, it is an author's right. It is a legal term used to describe the rights that creators have over their literary and artistic works. Works covered by copyright range from books, music, paintings, sculpture, and films to computer programs, databases, advertisements, maps, and technical drawings. In other words, copyright is a legal right that is given to the original creators with regards to their literary and artistic works, such as books, music, paintings, sculpture, research, computer programs, and the like. For example, you have completed your research in a certain subject. The research was done very well. You were able to answer and find solutions to all the problems. Aside from that, you have presented concrete evidence that supported your arguments. Suddenly, your teacher was planning to publish your work on the internet. But before that, it is important for him to ask a permission first from you because you were the creator or the writer. It is your privilege to be acknowledged by someone who will publish or make use of your work. So what are the types of rights under the law of copyright? So these are the rights that authors are entitled to according to the law of copyright under Part 4 of Republic Act 8293 or the Intellectual Property Code of the Philippines. In other words, copyright laws protect the rights of the author, artist, or other originator of a creative work to control when and how his work can be copied and disseminated, and it prevents others from appropriating the work without permission. So now let us discuss the types of rights under the law of copyrights. So first, it is the economic rights. So when we say economic rights, this allows a creator to ask for or obtain payment for the use of his or her work by third parties. So in other words, the term economic rights refers to the exclusive right of the right holder to authorize or prohibit the reproduction, distribution, exportation or importation, or other exploitative activities such as rental and lending, public performance, communication to the public, and adaptation in cases of copyrighted work or use and storage in cases of trademarks of the by intellectual property rights protected creation by third parties, which have not previously obtained a license within the borders of the states in which the intellectual property right has been granted or obtained. Furthermore, according to Section 177 of the Law of Copyright, these rights consist of the right to allow, impede, or carry out the following by the author. Replication of the work. That is the first. So, meaning to say, reproduction of original works will only constitute infringement if it has been expressed in material form. For example, photocopying, scanning, recording, or reproducing in a different format would be an infringement of copyright unless you have obtained permission from the copyright owner. Another example, in the modern context, copying a song on a compact device or any sound and visual recording can be considered as a reproduction of the content. Prior to copying, the permission of the author is required unless it can be shown that such copying is not intended to make any commercial benefits out of it. Next, transformation or dramatization of the original work. In other words, adaptation can include translating the work into another language or any other type of arrangement of the original work. If you want to use copyright material in a way that is covered by one of these rights, you must obtain permission from the copyright owner. For example, making a movie based on a novel. So here, to make any derivative work, the consent of the owner is mandatorily required. In these situations, certain other rights of the owner also come into play, like the right to integrity, which protects the owner against deformation, defacement, or modification of his work in a way that it is harmful for his reputation. Next, the first public distribution of the original work and each copy of the work. So meaning to say, apart from the right to reproduce the work, the author is also vested with the right to distribute the work. It is the right to put copies of the copyrighted work into the commercial market. That is, it relates to the control over dissemination of actual physical copies of the work. The scope and extent of this right are not uniform, that is, it differs with the work. Once copies are in circulation, the right no longer exists, that is, the right gets exhausted. Next, rental of the original work or copy of the work embodied in any form, including audiovisuals, cinematography, sound recordings, computer programming, or graphic work, regardless of ownership of the original work. So meaning, copy or rent the original work in any form is okay, including audiovisuals, cinematography, sounds recordings, and the like, as long as you will not possess the original work as your creation. For example, in vlogging, it is okay to use any audiovisuals and video clips that may add more loveliness to your video, but do not consider as your own. Next, public display of the original or copy of the work. In other words, publishing refers to making the work public either in print or electronic format. For example, if you are thinking to put up a business, and of course, in business logo is so essential for your business to be recognized and patronized by the customers. Therefore, in creating your business logo, it is necessary to obtain payment for you to make use of some pictures, text, software, and other application that you may need in editing so that you will not violate the right of the creator. Next, public performance of the work. Performing the work in the public includes any mode of visual or oral presentation. The owner of the copyright has the right to publicly perform his works. For example, he may perform dramas based on his work or may perform at concerts, etc. This also includes the right of the owner to broadcast his work. This includes the right of the owner to make his work accessible to the public on the internet. This empowers the owner to decide the terms and conditions to access his work. And lastly, the other communication of the work to the public. Another important right conferred on the author of a work is the right to communicate his work to the public. The exclusive right to do this vests with the author, irrespective of the nature of the work. Change in technology has brought change to the nature of communication and also to the notion of the public. This has enabled basically three kinds of communication, such as being public performance, being carried on in the presence of an audience, transmission through cable network, and also wireless broadcasting. And the right to communicate the work through all these means vests exclusively with the author. So now let us proceed to the next types of right under the law of copyright, which is the moral rights. So when we say moral rights, these rights allow the author of the work to maintain his or her personal connection to the work and to undertake measures in order to protect this connection. In other words, unlike copyright, you cannot transfer or sell this, but you can waive them. They give the creator the right to be acknowledged as the originator and to object to derogatory treatment of the work. The concept of moral rights relies on the connection between a person and their creation, as moral rights constitute the right of the creator to protect the integrity and ownership of their work to maintain the indestructible creational bond that exists between their personality and their creation, and as such can only be held by natural person. Furthermore, the author of the work, independent of the economic rights, also have the right to, first, require the authorship of the work be attributed to him or her. So meaning that the author may require that his or her name be displayed in a prominent fashion on a copy or public distribution or use of the work. For example, in research, it has a chapter there that you need to find related literature and studies for you to support and strengthen your arguments, right? So it is important to be included the author's name and as well as the date of publication before or after the statements that you will get from the internet to recognize his or her work. Next, to make any transformation nor adjustment to the work or withhold it from publication. So meaning to say, it is an author's right to his or her work to control if from publication if the work has made any transformation nor adjustment. For example, you have finished writing an article and it is about to publish, but there are some parts that need of revision or adjustment. Therefore, it is your privilege whether you stop it from publication or you would allow them to revise your article and be published. Next, to oppose any and all mutilation or any other derogatory action to the work which could potentially be detrimental to the author's honor and reputation. So in other words, it is a privilege of every creator to counter prejudice completely and whatever harmful action to the creation which might be damage the prestige and grandeur of the author. For example, the artwork Mona Lisa that was painted by Leonardo da Vinci. Some people make a fun to his artwork. They edited the artwork and posted into social media as meme, right? Therefore, he has a right to oppose such derogatory actions because his honor and integrity as an artist has been deteriorated. Next, and probably the last, to refuse to the use of the author's name on any mutilated or distorted version of his work or any work not of his own creation. So in other words, the author has the right to reject the usage of the author's name on all twisted replication of his or her work, not of his or her composition. For example, in research, as what I've said a while back, that the research has a part which you need to find related literature and related studies that will support your ideas, and we know that it is not easy to find an accurate one. Sometimes we found correct statements, but there is no author and the date of publication, which is the most important thing to prove that statement is not written or mentioned. Frequently, we have that attitude that if we did not find the name of the creator and that statement is totally adequate to support our arguments, we just put someone who has the same thought with the idea that we found out, which is completely derogatory action because we violated the moral rights of the author, that he or she has the privilege to maintain his or her personal connection to the work. So next, we will discuss the exceptions to the moral rights. So first exception, under Section 195 of the Law on the Copyright, an author may waive his moral rights through a written contract. So meaning to say, according to Section 195 of the Law on the Copyright, through a written contract, the author's moral rights may cancel. Depends on what is being written on the paper or contract that was officially signed by the author. It could be the terms and conditions that pertains to what is being agreed upon on the creations of the author. However, this contract is deemed invalid if it allows third parties to do the following. First, make use of the author's name, the title of the work, or the author's reputation in any version or adaptation of the work which could harm or be detrimental to the artistic reputation of another author. So, meaning to say, this pertains to the right of integrity, meaning it is the author's right to object to the destruction or modification of his or her work in a way that would harm his or her honor or reputation. Second, make use of an author's name for a piece of work not of his own creation. So, meaning to say, this pertains to the right of attribution, meaning it compasses not only the right of an author to have his or her name associated with his or her works, but also the right to not have his or her name associated with works that are not created by him or her. So next exception to the moral rights is the right of an author to have his contribution to collective work credited to his name is deemed waived. So meaning to say, a collective work here is defined as work created by two or more persons and under the understanding that the work will be attributed to the person whose direction said work is under. It is also understood that contributing natural persons will not be identified. But on the other hand, a collective work may not only credit to the original creator. It may also include all the people behind that creations. They should also have the rights to be acknowledged by their contributions. For example, publishing a music video on YouTube or premiering a movie on a big screen. Since you were the artist who took performance or actions with the music video or in big screen, you were not only the one who would be credited. The producers, videographers, directors, editors have also the rights to be recognized. And the last exemptions to moral rights, if an author licenses or permits a third party to make use of his or her work, any necessary transformation such as arranging, editing, or adaptations of work for use in publications, broadcasts, or motion pictures in accordance with the standards of the medium in which the work is to be used, shall not be found in contrary to the author's right. In addition, the destruction of work unconditionally and completely transferred by an author shall likewise not be found in violation of the author's right. So meaning, there is no violation of the author's right if a third party allows by the author to make use and any necessary transformation of his or her literary and artistic works. For example, making use of motion pictures in your PowerPoint presentation. You have the freedom to do or include whatever motion pictures that is needed to your presentation as long as the creator permits you to make use of his or her creations by signing up or logging in on such particular websites. And for our generalization, copyright arises automatically when an original work is created. Copyright protects original works of authorship, which include paintings, illustrations, sculpture, photographs, books, articles, dissertations, poems, movies, songs, recordings, logo, designs, websites, software, code, and more. There are two types of rights under the law of copyright. Economic right, which allow a creator to ask for or obtain payment for the use of his or her work by third parties, while moral rights allow the author of the work to maintain his or her personal connection to the work and to undertake measures in order to protect this connection. These types of rights under the law of copyright are necessary to be tackled for us. Students know our limitations to make use of different literary and artistic works by considering every author's rights. So, if you want to visit those informations that I have put on my presentation, these are the links displayed on your screen. And that's all. Thank you for listening, everyone. I hope you learned from this day. Goodbye and God bless.